Good afternoon, everybody. Can I extend a very warm welcome to you all, and welcome to our first in a series of personal injury talks for 2022. For those of you who don't know me, I'm Martin Porter. I'm delighted to be joined by Wyles and Kate Legh to give you a road traffic update, which will focus on questions of liability and in particular on questions of contributory fault. I'm going to kick off with the recent revisions to the Highway Code. Now, there's been a fair amount of brouhaha in the tabloid press just recently over this, and I'm going to endeavour to give a lawyer's rather than a tabloid perspective. Now, everyone who uses the roads should, of course, know the Highway Code. Lawyers who deal with road traffic collisions must be familiar with the Highway Code, as they are bound to feature prominently in letters of claim, letters of response, pleadings, and ultimately cases that go to trial and cross-examination. A powerful question to any motorist is to ask them how familiar they are with the Highway Code. The status of the Highway Code, I possibly do not need to remind you all. It has a somewhat intermediate position between legislation and government guidance. The Road Traffic Act 1988, section 38, provides that a failure on the part of a person to observe a provision of the Highway Code does not of itself render that person liable to criminal proceedings, but such failure may, in any proceedings, and those include civil proceedings, be relied upon by any party to those proceedings as establishing or negative any liability. Because this is the personal injury group, we will essentially leave criminal considerations to one side and focus upon the establishing or negativing of any liability in civil proceedings. The code is also of considerable importance when courts are dealing with questions of contributory fault, and you will recall that the Highway Code was relied upon heavily by the Court of Appeal in the case of Fruman Butcher as justifying deductions for contributory negligence for failure to wear a seatbelt in the days before it was required by law seatbelt award, but after it had been recommended they should be in the Highway Code. The current amendments to the code are brought by the Secretary of State, who's currently Grant Shapps, and he has the power to revise the code in any manner as he thinks fit. What he's required to do under the legislation is to lay the proposed revisions before Parliament, and then a period of 40 days later, they take effect. Grant Shapps laid the proposed amendments before Parliament on the 1st of December 2021, and in the absence of any resolution from Parliament, they therefore come into effect on Saturday, the 29th of January 2022. It is to be hoped at that point that they will then be published, and they'll certainly be published as the law requires it, but even more importantly, fully publicised. This is the first major revision to the code since 2007. It follows a detailed consultation by the Department for Transport that has been going on since October 2018. So this has been talked about for a number of years now. Considerable credit needs to be given to a large number of groups representing pedestrians, cyclists, and horse riders for pushing for some of the changes that have come about. I know there's been substantial work by various groups, including those with whom I am personally associated, make that declaration of interest. Full-scale revision, which is hinted at in the consultation, will no doubt involve thorny issues around liabilities relating to self-driving vehicles, but that is for a future point. Now, I cannot cover every change in this talk in the available time, but I hope that a whistle-stop tour of some of the more important ones will prove to be helpful. We get off to a good start, a change in the introduction to the code. Gone is the considerate towards each other mantra, which, whilst well-meaning, rather overlooked the differing destructive potentials of different road users on our roads, in with the supporting of healthy, sustainable and efficient transport system. The changes centre on the new hierarchy of road users. This is a concept that is very much borrowed from countries not very far to the east of here, where cycling in particular has become culturally more associated with ordinary people in ordinary clothes going about ordinary business. And those of you who do cross-border litigation will recognise echoes of European systems in this hierarchy, though the code has not, could not, since it does not involve primary legislation, go the full way towards imposing strict or presumed liability. But you'll see there's a new H1, that those in charge of vehicles that can cause the greatest harm in the event of collision bear the greatest responsibility to take care and reduce the danger they pose to others. So the priority is generally pedestrians, greater than cyclists, greater than horse riders, greater than motorcyclists, greater than car drivers, greater than HGV drivers. And new rule 204, in any interaction between road users, those who can cause the greatest harm have the greatest responsibility to reduce the danger or threat that they pose to others. New rule H2, everyone needs to watch out for pedestrians who are at the top of the hierarchy. Horse riders give way to cyclists on parallel crossing. Conversely, cyclists give way to horse riders on bridle roads. H3 is a reflection of the Turning the Corner campaign run so successfully by British Cycling and Chris Boardman in particular. Those who, if you're cycling and you're going straight on, then you have priority. So revised rule 67 though recommends caution when cycling to the left of large vehicles, particularly where they may be about to turn. But new rule 76 makes clear in terms that there's priority for cyclists going straight ahead at a junction. As I've indicated, this new hierarchy borrows extensively from experience in other countries, but it broadly codifies civilized conduct. It formalizes and develops the way that the common law has been moving in any event. I take as an example the Court of Appeal decision in McGeer and McIntosh, that should be Lord Justice Tracy, who was clear that it was appropriate for the trial judge to take into account the causative potency of an HGV, given the likelihood of very serious injury to a cyclist in the event of collision. So the judge was entitled to find that it was potentially a very dangerous machine. Its size and bulk were such that in the event of collision, it constituted a very serious danger to a person in the position of the claimant. So in short, the bigger the threat, the bigger the duty. And that is so when considering issues of primary liability and also questions of contributory fault, as was the case in McGeer. Rule 19 provides improvement from pedestrians' perspective as to the rules at zebra crossings. Hitherto, traffic has not had to stop for a pedestrian unless and until someone has actually stepped onto the crossing. That remains the formal law, though the amended rule in the code now clarifies that drivers and riders should give way to pedestrians who are waiting to cross. This applies through new rule 206 also to junctions. When turning at road junctions, you should give way to pedestrians who are crossing or waiting to cross the road into which or from which you are turning. Rule 52, we do a fair number of cases in these chambers involving animals and horses. So I want to mention that Rule 52 encourages British Horse Society training for horse riders, and any horse rider who's acting in accordance with that training is therefore most unlikely to be criticised by any court. Rule 59 has changed to some extent. It's an old bugbear of mine in relation to putting the responsibility on cyclists for wearing clothing that they wouldn't wear in ordinary everyday life. So the advice to wear a helmet remains, but some text has been added as follows. Evidence suggests that a correctly fitted helmet will reduce your risk of sustaining a head injury in certain circumstances. So those of us who do these cases will be well familiar with the difficulties that defendants face in proving, of course, with contributory negligence, the burden of proof is on the defendant, that contributory fault on the part of a cyclist in not wearing a helmet has made any difference to the head injury sustained. Rule 59 also deals with light-coloured or fluorescent clothing during the day, reflective clothing at night. But this advice too is altered subtly to say that those can help other road users to see you and increase your visibility, rather than the previous impression that they necessarily would. We're all familiar with the fact that such clothing is of no assistance whatever if a driver doesn't actually look. Please note that there is no advice for cyclists to use daytime lights, and please note also that there's been no change in Rule 3, which contains the advice to pedestrians to help other road users to see you by wearing light-coloured or fluorescent clothing. Rule 61 has some significant changes to it and deals with the use of cycle facilities, and in particular the voluntary nature of such facilities. The new rule is clear that cyclists may exercise their judgment and are not obliged to use them, which is rather clearer than the old Rule 61, should read 61, that such facilities should be used unless unsafe, with the slightly begrudging footnote that they were not compulsory. This revision should certainly help to prevent cases like Harvey Daniel Cadden going back to 2006, where a cyclist was infamously initially convicted of inconsiderate cycling for failing to use a cycle lane alongside a road. His conviction had to be overturned on appeal to the Crown Court. This new rule should help also with contributory negligence, to get back to the civil context that I'm talking about, in cases like Group Captain Tom Barrett and Luca, a case from 2012, where the commanding officer at RAF Norfolk was run down using the A40 dual carriageway, where contributory negligence was alleged for not using a cycle track which ran alongside that road. Rule 66 is of interest to those who ride in groups. For the first time in the Highway Code, we have the specific sanctioning of riding two abreast, and even arguably encouraging it. So the old rule, never ride more than two abreast, ride in single file on narrow, busy roads when riding around bends, was unsatisfactory in a number of respects, has now been replaced with the following: be considerate of the needs of other road users when riding groups. You can ride two abreast, and it can be safer to do so, particularly in larger groups or when accompanying children or less experienced riders. It goes on to say in the final sentence, which was added quite late in the consultation process, be aware of drivers behind you and allow them to overtake, for example, by moving into single file and stopping when you feel it is safe to let them do so. This last sentence is potentially going to give rise to controversy. It is, though, I suspect, very unlikely to impact civil proceedings given the hierarchy. So if you're cycling and you don't stop, the vehicle behind will not be able to use that as an excuse to squeeze through, because it would be impossible to do so without breaching the overtaking rules that I will come to next. The Rule 163 on overtaking has been substantially changed. Firstly, there is the express authorization of filtering, albeit with caution, which you can read there. But of even greater significance, the guide that's now introduced into the code, that motorists should leave at least 1.5 metres when overtaking cyclists at speeds of up to 30 miles an hour, and give them more space when overtaking at higher speeds. And more space, I venture to suggest, means 2 or 2.5 metres, rather than say 1.6 metres, although the code is not specific as to what is meant by more space. There's also help for horse riders. You should pass them at even lower speeds and allow even greater distance. These overtaking guides will no doubt be of considerable assistance to those police forces who have been following the lead of the West Midlands Traffic Police in conducting close pass operations. There's further advice for overtaking pedestrians, at least 2 metres of space at low speed when passing a pedestrian who's walking on the road. The code is not specific on how motorists should conduct themselves when passing pedestrians, say, on a narrow pavement, but I venture to suggest it should be giving substantial room in that situation as well. Extra care and more space is required when overtaking in poor weather conditions, including high winds, and at night. So the previous recommendations are a guide and need to be increased if the weather conditions dictate, or even if it's simply nighttime. And finally, you wait behind the motorist, cyclist, horse rider, horse-drawn vehicle, pedestrian, and not overtake if it is unsafe, or if it is not possible to meet these clearances. So, because it's all, you stay behind, even if you think it's safe to overtake. And it's very important that cycling is perceived by those who try it out to be subjectively safe. So there is good reason for those clearances that should not be overruled by motorists' own perception of what is or is not safe. Roundabouts, often, unfortunately, a place where cyclists are knocked over by motorists. New Rule 186, or new added wording to 186, makes it clear that motorists give priority to cyclists on the roundabout and explains that many cyclists will not have the self-confidence to approach a roundabout, particularly if it's a large or complex roundabout, in the same way as they would if they were in a motor vehicle. And motorists are specifically warned that cyclists may well go around the roundabout, keeping to the outside and therefore coming into potential conflict with motorists at each exit. And motorists have to be aware of that and to take account of that. Arguably, as recommended by Bikeability and Cyclecraft, it's safest for a cyclist who's turning right at a roundabout to position himself or herself in the same way as a motorcyclist would, but in the real world, it cannot be expected that all cyclists are going to be willing to do that. Positioning is dealt with in the Highway Code for the first time in the revised Rule 213. So on narrow sections of road, on quiet roads or streets, and most importantly, at road junctions and slower moving traffic, cyclists may sometimes ride in the centre of the lane rather than towards the side of the road. It's explained that it could be safer. It's explained that groups of cyclists can ride 2 abreast in those situations, allow them to do so for their own safety to ensure they can see and be seen, allow them to ride at least a metre from any parked cars to avoid dooring. This is a step in the right direction, but it's still not as strong as the advice in Bikeability and Cyclecraft, which teaches cyclists to ride in the centre of the lane, which is called the primary position, and that it is safe to move over towards the left to facilitate overtaking, and in those circumstances, never to go too far to the left. And note also that in urban environments, such as in London and other major cities, the cyclist is very likely to remain in the centre of the lane, given that you are always near a road junction of one form or another, and that an average cyclist can keep up with the average speed of motor traffic in a major urban centre. So the Highway Code, for the first time, at least spells out that this is an acceptable practice. Rule 239 recommends that when opening a car door, you do so with the hand that is furthest away from the door. Philip Hammond, when he was Transport Secretary, thought this was a ridiculous thing to suggest motorists should do, but we have all come across those unfortunate dooring cases, and this does help and does eventually become ingrained habit, as has long been the case in the Netherlands. It is much easier to look back and check that there's no cyclist approaching if you have used the opposite hand, which forces you to turn around and look. Finally, the small revisions in the annex to the code. The former recommendation that you fit a bell becomes you should fit a bell. I'll leave that there. It's not often I venture to suggest that collisions are avoidable by the use of a bicycle bell, but there is some force in saying that they are a polite reminder or warning to pedestrians on shared use facilities. Also in Annex 1, the recommendation for cycle training is expanded with an explanation of what bikeability is. So bikeability is now finally recognised in the Highway Code. And if you are riding in accordance with bikeability training, you should not be criticised by any court. So overall, to sum up, broadly, these changes are very positive for pedestrians, cyclists, and horse riders. They're not perfect. The bits about stopping when necessary to let traffic behind overtake are certainly not ideal. The Rule 59, even as amended on clothing, will continue to differentiate us from the culture that is discernible in the Netherlands, but we have a step, maybe even a stride in that direction. So thank you. I'll now hand over to Kate.
Thank you, Martin. Good afternoon, everyone. I'm now going to talk to you about contributory negligence and drunkenness, and specifically the Court of Appeal's decision last November in Campbell and Advantage Insurance. The case raised the issue of whether a drunken passenger can rely on his or her own drunkenness to avoid finding contributory negligence in an accident caused by a drunken driver. The very sad facts of this case were that the claimant, Liam Campbell, was an unrestrained backseat passenger in a vehicle driven by his friend, Dean Brown. Mr. Campbell and Mr. Brown had been drinking together in a nightclub, together with Mr. Brown's brother, Aaron Brown, after which Dean Brown set out to drive himself and Mr. Campbell home. To make things simpler from now on, I'm going to refer to Aaron and Dean by their first names, but no disrespect is intended. Both Mr. Campbell and Dean were very drunk, and during the journey home, there was a serious collision with a lorry travelling in the opposite direction. Sadly, Dean was killed in the collision. Mr. Campbell's head collided with the back of the driver's seat, and he suffered catastrophic brain damage. Proceedings were brought by way of his father as his litigation friend. Aaron, who was not in the car at the time of the collision, sadly took his own life before trial. Advantage, who were Dean's insurance company, admitted liability for the accident, but contended that Mr. Campbell's damages should be reduced. Firstly, because he was not wearing a seatbelt, and secondly, because he had allowed himself to be driven by Dean, who had obviously been drinking to excess. At trial in March 2020, there was no direct evidence given. Dean had died in the collision, and Mr. Campbell was unable to give evidence due to his brain damage. Aaron had given witness statements to both parties, but he had died by the time of trial. His Honour Judge Robinson, sitting as a judge of the High Court, found that although Mr. Campbell was not wearing a seatbelt, this had no causative effect because he would have suffered catastrophic head injuries in any event. So he didn't make any deduction on that basis. However, the judge found that Mr. Campbell should have appreciated that Dean had drunk too much. The judge made a 20% reduction for contributory negligence on that basis. This was challenged by Mr. Campbell, and the Court of Appeal therefore needed to decide the following 4 issues. Firstly, whether the judge had wrongly applied a test of capacity under the Mental Capacity Act 2005. Secondly, whether the judge's findings of fact were properly made. Thirdly, whether the judge wrongly applied a test of objective, reasonable, competent and prudent passenger when Mr. Campbell was too intoxicated to be held responsible for his actions. And fourthly, whether the judge's assessment of 20% contributory negligence should be reduced. Before addressing each of these issues, it's important to look at the detail of the judge's findings, as it's the detail which is central, I think, to the ultimate decision in this case. On the night in question, Mr. Campbell started drinking at about 8:30 or 9 p.m. At around 10 p.m, Dean arrived, and both of them then went to Aaron's house. All 3 of them left for a nightclub in Mr. Dean's 3-door car, and they parked about 5 minutes from the club. The judge found that all 3 men drank equally at the club, and they drank a lot. By about 1 o'clock or 2 o'clock in the morning, Mr. Campbell was extremely drunk. Bouncers were removing him, and he was unable to stand on his own. Aaron and Dean walked Mr. Campbell back to the car, and they put him into the front seat of the car. Mr. Campbell passed out. The other 2 went back to the club to continue drinking. An hour later, Aaron and Dean returned to drive home, but the car wouldn't start. Aaron went to try and find jump leads, and when he returned, the car had gone, with Dean and Mr. Campbell in it. Thus far, the judge had the hearsay evidence from Aaron to go on, but then this is the important bit. Aaron had left Mr. Campbell in the front seat of the car, but by the time the accident happened, Mr. Campbell was in the back seat. There was no evidence of what had happened in the intervening time period, so the judge needed to piece together the events himself. The judge found there were 2 possibilities. Either Mr. Campbell had woken up, or Dean had moved him into the back seat. The judge found it was likely that Dean wanted to move Mr. Campbell into the back seat so that Aaron, when he came back, could get into the front seat of the car. Otherwise, he would have had to have climbed over Dean or Mr. Campbell. It was unlikely, said the judge, that Mr. Campbell could have sobered up sufficiently to manoeuvre himself into the back seat alone. He must therefore have been assisted. However, Mr. Campbell was sufficiently heavy and sufficiently tall that he must have been awake as he was being moved, because it would not have been possible for Dean to move him into the back seat of the car without assistance. Ultimately, therefore, the judge found that Mr. Campbell must have been aware of what was happening. He consented to remaining in the car as it was driven away by Dean, at a time when he was aware that Dean had consumed so much alcohol that his ability to drive was impaired, and his ability to drive safely was impaired. The judge applied an objective test and found that a reasonable man in Mr. Campbell's shoes would have concluded that Dean was not safe to drive. Accordingly, it was inevitable, said the judge, that finding of contributory negligence needed to be made, which he assessed at 20%. The first issue for the Court of Appeal was whether a proper reference to the Mental Capacity Act had been made. However, this is slightly something of a red herring. The issue of capacity arose on appeal because the judge had found that the presumption in favour of capacity under the Act was not displaced by Mr. Campbell having drunk more than the other 2 men. That conclusion was appealed by Mr. Campbell. In the Court of Appeal, Lord Justice Dingemans observed that it was unsurprising that the judge had addressed the position under the Mental Capacity Act, given that the particulars of claim contained the statement, well knowing that the claimant was unable to reach a capacitous or informed decision. There was, however, said Lord Justice Dingemans, no error of law in the judge's decision. In his short concurring judgment, Lord Justice Underhill explained that a reference to the Mental Capacity Act was not necessary or even particularly useful, albeit he agreed with Lord Justice Dingemans that there was no error of law in the judge doing so in this case. Accordingly, it seems clear, I think, that consideration of capacity under the Mental Capacity Act 2005, or even under the common law, is unnecessary in drunken passenger cases. That was simply a tangential issue that had been thrown up by the pleadings. The next issue for the appellate court to consider was whether the judge had impermissibly speculated about how Mr. Campbell came to be in the back of the car. The Court of Appeal adopted the ordinary approach to appeals against findings of fact that is, whether the findings of fact were perverse in light of the evidence available to the judge, or whether there was any justiciable error in the judge's decision. Ultimately, said the Court of Appeal, this was a case where the evidence was sadly lacking. The judge had identified 2 ways that Mr. Campbell could have got into the back seat, and it was important to note that the alternative method, so if Mr. Campbell had changed seats by himself, that alternative method would hardly help him. It was not right, said the Court of Appeal, for other possibilities to be considered. For instance, a group of passing people stopping to assist Mr. Campbell into the back seat at 2 o'clock in the morning so that he could be driven away by an obviously drunk man, which was the claimant's suggestion. There was no evidence to support that contention, and instead the Court of Appeal concluded that the judge's finding was based on the facts and he had not strayed impermissibly into speculation. The third issue is perhaps the most important issue and the one most likely to be of assistance to personal injury practitioners in the future. On appeal, those acting for the claimant argued that the judge had wrongly applied an objective standard when assessing whether Mr. Campbell was guilty of contributory negligence. They referred to a decision from the Queensland Court of Appeal in Australia called McPherson and Whitfield. In that case, the court said that passengers who had agreed to be driven by a drunk driver were not at fault if they could not appreciate the implications of their agreement to be driven by the drunk driver at the time of agreeing to be driven. This was, to the claimant, consistent with the decision of Mr. Justice Watkins in the English decision of Owens and Rimmel. The Court of Appeal in Campbell started by reminding itself that under the Law Reform Contributory Negligence Act 1945, the word fault in section 1 of the Act meant negligence, breach of statutory duty, or other act or omission which gives rise to a liability in tort. Now, of course, the test of whether someone has breached a duty of care and negligence is an objective standard. It's that of the reasonable and prudent man or woman. That standard would, of course, apply to Dean as the driver. Advantage, as Dean's insurer, would not be able to rely on his drunkenness as a defence to the claim. The starting point, therefore, was that there was no principled reason why a different standard should be applied to Mr. Campbell when assessing whether he had been contributory negligent in agreeing to be driven by Dean. Moreover, said the Court of Appeal, in Joslin and Berriman, which was a High Court decision from the Australian High Court, the court had disapproved of the line of cases, including McPherson and Whitfield, instead emphasising that an objective test should be applied to the drunk passenger who agreed to travel with a drunk driver. Owens and Rimmel was an English case where the issue of contributory negligence for a drunken passenger accepting a lift from a drunken driver was considered. Passenger and driver had been on a pub crawl together and had drunk 8 or 9 pints. On the way home, the driver hit a lamppost and the passenger suffered serious injuries. A reduction of 20% for contributory negligence was made. Those acting for the claimants in the present case sought to rely on a particular passage in Owens and Rimmel, which I put on the slide. And they sought to rely on this passage to argue that there were only 2 bases for contributory negligence of a passenger. Firstly, where a passenger, although they have had some alcohol, is still able to process the risks. Or secondly, where a prior agreement is made between driver and passenger for the passenger to be driven later on before the passenger then drinks to excess so that he or she cannot process the risks. The claimant submitted that there was no such agreement in this case on the judge's findings and that neither category therefore applied here. Unsurprisingly, the Court of Appeal dismissed this argument. Owens and Rimmel was not to be read so strictly. In fact, in that case, Mr. Justice Watkins himself had emphasised the fact-sensitive nature of the inquiry. He had expressly found it to be more likely that the passenger had not given thought to the risks before the pub crawl started, and by the end, both passenger and driver were equally befuddled by drink, so as to rid them of clear thought and perception. Nevertheless, Mr. Justice Watkins made a finding of contributory negligence in that case. The Court of Appeal also referred to the case of Booth and White, which I've put on the slide. In his concurring judgment in Campbell, Lord Justice Underhill agreed that it's now clear that a claimant's drunkenness will not be a relevant characteristic in deciding whether he or she took reasonable care for their own safety. He cited with approval paragraph 453 of Charlesworth and Percy, which I've placed on the slide for you to refer to. But, said Lord Justice Underhill, the best explanation of the law, and I think the reason why the judge's findings of fact are likely to be so important in each case, was a paragraph from the Australian decision of Joslin and Berryman, which he quoted in full. And I'm going to read that out. It states, hence, the issue is not whether a reasonable person in the intoxicated passenger's condition, if there could be such a person, would realise the risk of injury in accepting the lift. It is whether an ordinary reasonable person, a sober person, would have foreseen that accepting a lift from the intoxicated driver was exposing him or her to a risk of injury by reason of the driver's intoxication. If a reasonable person would know that he or she was exposed to a risk of injury from accepting a lift from an intoxicated driver, an intoxicated passenger who is sober enough to enter the car voluntarily is guilty of contributory negligence. The relevant conduct is accepting a lift from a person whose driving capacity is known or can reasonably be found to be impaired by reason of intoxication. So, Lord Justice Underhill explained that alcohol is not altogether irrelevant. A person who is passed out from drinking too much and who is put unconscious into a vehicle will not be guilty of contributory negligence, since they have done no voluntary act. They simply haven't consented to being driven. And this is the tricky bit, Lord Justice Underhill said that there may even be cases where a person who is not totally unconscious may nevertheless be in a state where they are incapable of making a decision. Ultimately, it's the difference between drunken consent and no consent. So if Dean had driven off when Mr. Campbell was passed out in the front seat, it might, said Lord Justice Underhill, be difficult to find that he had consented to being driven. But of course, that's not what the judge found. The judge found that Mr. Campbell was aware of what was happening. He consented to remaining in the car while it was driven away by Dean at a time when he being Mr. Campbell, was aware that Dean had drunk to excess. Finally, the Court of Appeal reiterated that the apportionment of responsibility is, as with making findings of fact, very much a matter for the trial judge. The appellate court can only interfere where judgment exceeded the ambit where reasonable disagreement was possible and the court below had gone wrong. That had not happened in this case. So what can we take away from the Court of Appeal's decision in Campbell? First of all, it's the latest in a long line of cases which exemplify the appellate court's reluctance to disturb both the judge's findings of fact and apportionment of contributory negligence. In terms of the law itself, there are two particular conclusions to note. First of all, the question of capacity is unlikely to be irrelevant. While it's not an error of law to refer to capacity as such, it's a distraction from the central issue. Secondly, while certain characteristics will always be taken into account in assessing contributory negligence, for example, age and possibly disability, when it comes to the drunken passenger, the test is that of a reasonable and prudent, sober man or woman. But that's not to say, of course, that a passenger's drunkenness is irrelevant. In each case, the court needs to make a judgment call in respect of whether the passenger voluntarily consented to being driven and whether they were capable of doing so. An unconscious person clearly cannot consent, but it's clear from Lord Justice Underhill's judgment that nor can those who are not totally unconscious, but may nevertheless be in a state where they are incapable of making a decision. Now, I think that sounds to me like the right approach in the abstract. I think in practice, that distinction could prove very difficult, and clearly it comes down to the individual facts of each case. Thank you very much. I'm now going to hand over to Lucy.
Thank you very much, Kate, and good afternoon, everybody. I'm going to be following on with the issue of contributory negligence, but I'm going to be looking at cases where children are concerned. In particular, I'm going to look at the recent Court of Appeal case of Ghoul and McDonagh, but I'm also going to look back at some other recent cases dealing with this issue. So slightly unusually, I'm starting with the newest case first. And as we all know with road traffic cases, every case depends on its own facts and authorities are of limited assistance. But nonetheless, it may be illuminating to consider how judges approach this particular issue, which can engender emotion and particular considerations. So some of the issues that come up when dealing with contributory negligence in children First of all, it's well established that the degree of care to be expected must be proportionate to the age of the child. Obviously, that means the older the child, the more care should be expected. And how you work out in any particular case what degree of care is to be expected from, for example, a 9-year-old child is a matter of fact for decision on the evidence. One of the questions that comes up is whether there is a minimum age for a finding of contributory negligence. When you're talking about someone who's 5 or 6, is it realistic that there's going to be any finding of contributory negligence if they run across the road without looking, even if they do know the Green Cross Code? And at the other end of the scale, a 16-year-old or 17-year-old is very unlikely to be treated in respect of contributory negligence any differently from an adult. And the Court of Appeal case of Taddean, Hubble and Coles, in which Ben Brown and Roger Harris of these chambers acted, is a good example of that in relation to a 16-year-old cyclist who was treated no differently from an adult. And the other issue that comes up is whether there is some sort of minimum or maximum percentage for contributory negligence if a finding is made. And that's not a question that's limited to children, of course. I'm sure we've all been in situations where we've advised clients or said in a negotiation that there's no prospect of a reduction for contributory negligence of 90% or similarly of 10%, because that's not what judges tend to do. Let's just remind ourselves briefly of the statutory framework that those judges should be applying. And Kate just mentioned section 4, which deals with the definition of fault. But section 1.1 of the Law Reform Act 1945 is the provision which stopped it being a complete defence to a claim and turned it into a sharing of liability. And of course, what you need is a finding that any person suffers damage as the result partly of his fault, and then the damages recoverable shall be reduced to such extent as the court thinks just and equitable, having regard to the claimant's share in the responsibility for the damage. So you need fault, causation, and then a reduction which is just and equitable. And in Davis and Swan Motor, Lord Justice Denning, as he then was, explained that the amount of the reduction doesn't depend solely on the degree of causation. Causation is the decisive factor in determining whether there should be any reduction, but the amount of the reduction is such an amount as may be found to be just and equitable, having regard to the share in the responsibility. So this involves a consideration not only of the causative potency of a particular factor, but also of its blameworthiness. So when you're considering the reduction, those are the two ingredients. And as we'll see, the degree of blameworthiness comes very much to the fore when considering child claimants. And then in Goff and Thorne, Lord Denning gave some guidance specifically in relation to children and contributory negligence in his customary lapidary style. He said that a very young child cannot be guilty of contributory negligence, an older child may be, but it depends on the circumstances. The judge should only find a child guilty of contributory negligence if he or she is of such an age as to be expected to take precautions for his or her own safety, and then he or she is only to be found guilty if blame should be attached to him or her. The child has not the road sense or the experience of his or her elders. He or she is not to be found guilty unless he or she is blameworthy. And perhaps some slightly unhelpful language thereby referring to guilt as opposed to blameworthiness. But anyway, having reminded ourselves of the legal framework, we come now to the very recent case of Ghoul and McDonagh, which was an appeal on the issue of contributory negligence. The claimant was a 13-year-old boy who was struck by a car while he was crossing the road. The first defendant, Mr. McDonagh, had driven off at speed when he was approached by police in relation to his suspected criminal activity. And he was driving at least 40 miles an hour on a residential road with a 20-mile-an-hour limit. Now, at first instance, the judge noted that the boy was wearing headphones. It wasn't suggested that that in itself was negligent, but the judge said that when a person who is wearing headphones attempts to cross the road, it becomes more important for them to take a careful look at the traffic because they cannot rely on their hearing to warn them of danger. And the judge held that a reasonable 13-year-old making a careful assessment would have realised that that car was being driven much faster than usual, would have waited for it to pass. But even if the reasonable 13-year-old would have set off across the road, they'd have kept the car under observation, noticed it approaching at speed, gone a bit faster to get it and so got across in time. So there was a finding of contributory negligence. The judge held that given the blameworthiness of the defendant who was driving appallingly, it was just and equitable to reduce the claimant's damages by just 10%. Now that finding of contributory negligence of 10% was unusual. It's perhaps instructive to note that the defendant's counsel in that case had submitted that a range of 10 to 20% would be appropriate. He didn't aim any higher. Perhaps unsurprisingly, the claimant appealed, and the Court of Appeal identified that the three questions arose. First, was the claimant at fault? Second, causation, i.e. did the claimant suffer damage partly as a result of his fault? Third, if so, to what extent is it just and equitable to reduce his damages? And the appellant argued that the claimant's misjudgment in relation to the speed of the car was not blameworthy. But the Court of Appeal held that the judge was entitled to conclude that the misjudgment in crossing the road was indeed culpable or blameworthy. And then on the question as to was it just and equitable to reduce his damages, the Court of Appeal recognised that there were limited circumstances in which an appellate court could interfere with a degree of reduction, as Kate just mentioned, and that was looked at by the Supreme Court in the case of Jackson and Murray, which we're going to remind ourselves about in a moment. The Court of Appeal held in ghoul that 10% was unusually low, but was not outside the range of reasonable determinations, and there was nothing in the 1945 Act or any authority to preclude a finding of 10%, so the appeal was dismissed. In Jackson and Murray, a 13-year-old girl stepped out from behind a school minibus into the path of an oncoming car in poor lighting conditions, which the judge held made it difficult for her to assess the speed of the car, which was too fast in the circumstances. Now, this was a Scottish case, and there is some suggestion in the textbooks that traditionally the Scottish courts have been more robust in making findings of contributory negligence against children. Certainly in this case, at first instance, there was a finding of 90% contributory negligence for the child. On appeal, that had been reduced to 70%, and then the Supreme Court looked at the case and held that there was no satisfactory explanation of the court's conclusion that a major share of responsibility should be attributed to the child claimant, and held that the proper assessment was 50%. So we've had quite similar facts, 13-year-old child stepping out and not assessing speed, and in Jackson and Murray we've got a reduction of 50%, and in ghoul of 10%. The approach that for appellate courts was looked at by Lord Reed, and he said this: he recognised that it was not possible for a court to arrive at an apportionment which was demonstrably correct, that apportionment was inevitably a somewhat rough and ready exercise. Differing views of judges should be respected within the limits of reasonable disagreement. So an appellate court would need to be satisfied that the apportionment was outside the range of reasonable determinations. And so when the Court of Appeal in Ghoul and McDonagh were applying that, they found that 10% was not outside the range of reasonable determinations. I want to take you now to the case of Ellis and Kelly, which was a case involving a younger child, a child of 8. This was a decision of Mrs. Justice Yip in 2018. And the child was hit by a speeding car as he ran across a road close to a pedestrian crossing. The judge inferred that his previous experience was that cars would stop at the crossing, although I don't think there was direct evidence of that. And she held that at his age, he was unable to judge that the car was travelling too fast to stop. She found that there was no contributory negligence, and she also found that there was no contribution to be had from the mother for allowing the child out without supervision. The defendant had argued that if the child was not responsible, then his mother was for letting him out to use the road on his own. And the reason for seeking that contribution from the mother was to try to defeat the claim for her gratuitous care provided to the severely injured child as a result of the accident. Now, as I've mentioned, the judge found that there was no contributory negligence. And she rather elided the three questions that the Court of Appeal has reminded us need to be answered: fault, causation, and then whether it's just and equitable to make a reduction. She found that this was a case of momentary misjudgment balanced against reckless conduct on the part of the defendant, and simply found that it wouldn't be just and equitable to make a finding of contributory negligence in the circumstances. She also set out her view that it would be undesirable for law to expand so as to routinely attempt to regulate decisions and actions arising in the course of normal daily parenting. And as I said, the claim for contribution against the parent failed. However, in other cases, there may well be scope for seeking a contribution from a parent where a child sustained such an injury, particularly if the parent was on the scene, and it's certainly a point to be considered where there is a significant care claim. Then finally, and I mean this in the sense of approaching the end, there is the case of Alabadi and Akram, which was heard last autumn. And this was a child of 9 who was crossing a 3-lane carriageway at a light-controlled crossing in a group with her mother and 3 cousins. It was rather late at night, I think about 10:30 p.m, and the group were crossing on a red man signal. During the crossing, the claimant was about 2 meters ahead of the group when she was struck by a car. The rest of the group had stopped as the car approached. The car driver thought that he had the time and space to continue because the group had stopped, and he had the 3rd lane to use, and of course the light was in his favour. The judge found that the claimant must have been distracted and that she didn't notice the car, nor that the rest of the group had stopped. And it was held that the claimant, the child, was not at fault for crossing on the red man signal, and that a child of her age, 9, would naturally work on the basis that it was safe to follow the lead of her adult cousin and her mother, and that when she was on the crossing, her momentary lapse of concentration did not amount to fault, and that it would not be reasonable to expect a girl of her age to keep such a close eye on the group, so there was no contributory negligence. Interestingly, there does not seem to have been any claim in this case for contribution from the mother. And the judge added this, that had his decision called for apportionment, he said, I would have reached the firm conclusion, bearing in mind Khadijah's age and all the circumstances of the case, that the reduction in damages would have been minimal, and at most 10%. I would have regarded such a reduction as de minimis. I would therefore in any event have made no reduction in Khadijah's damages. Now that decision was a month before the appeal in ghoul, which affirmed, as we know, a reduction of 10%. So going forward, in the light of ghoul, it will now be difficult for judges to say that a reduction of 10% would be de minimis. And it would also be difficult to assert in negotiations that a finding of 10% contributory negligence is improbable. And of course, in a case involving very severe injuries, a reduction of 10% can represent a significant amount of money. So it may be that arguments about contributory negligence in children will now be pursued with a little more vigour. I hope that this review of recent cases has been of benefit. That does bring me to the end of my talk, and it brings us to the end of the seminar. Thank you very much indeed.